Objection. Some libertarians view efforts to encode definitions of marriage into law as a form of central planning in the social realm, and therefore not within the proper role of government on any level. After all, the argument goes, civil marriage and marriage licenses have been an instrument of the state to advance transparently unjust policies, such as bans on interracial marriage, and exist almost solely for those purposes. From this perspective, we should just get the government out of marriage altogether and return marriage to the churches to implement as they please. If we were to do this, the argument goes, there would be no need to have this debate in the first place. Those who make this objection often assume that prior to the implementation of marriage licenses, marriage was an entirely religious rite without any civil implications. This assumption is only partly true. It's true that requiring a government permission slip issued by a magistrate or judge prior to marriage is a modern phenomenon that has been used to oppressive ends. However, this doesn't mean that prior to marriage licensure, marriage partners incurred no legally enforceable moral duties to each other, or that marriage was no different than any other private religious ritual, such as baptism or the sacrament. To unpack this, however, we need to make a conceptual detour. To most libertarians, the moral right to property is something that governments do not create, but which they recognize and respect, or at least ought to. That is, the right to property philosophically precedes civil government and can be derived using state-of-nature thought experiments. We argue that the same sort of moral reasoning and state-of-nature thought experiments can also be used to explore the kinds of duties and rights that arise in the context of a procreative relationship. Consider a state-of-nature exercise. Does a father have any inherent obligations to his children and their mother, irrespective of and prior to any contract or agreement he's made? Does a mother have a legitimate claim upon the father of her children, irrespective of and prior to any contractual agreement or civil legislation? Do parents have a natural right to raise their children together according to their own discretion, absent severe abuse or neglect, regardless of whether civil governments respect that right? If the answer to each of these questions is yes, then procreative intercourse gives rise to obligations, as well as rights and privileges, that spouses have with regards to each other and their children. Civil marriage is simply the process by which courts minimally acknowledge, respect, and on rare occasions enforce or defend these obligations and rights, just like it acknowledges, respects, and defends property rights by providing recourse in a court of law when they are violated. Courts typically acknowledge marital rights and duties by promoting permanence, treating marriage and family as an autonomous legal unit, and enforcing the ongoing duties of material care and support, such as alimony, child support, etc., when the relationship otherwise breaks down. When a woman approaches a judge with a claim that her husband has violated his marital duties, for example, that he has neglected to materially care for and support the family, how does the court establish that the claim is legitimate? That is, that the children are really his. Prior to DNA testing, the only way to do this was to bring forth witnesses that the couple had publicly declared their intent to procreatively unite. In this way, wedding ceremonies have historically served an important civil function and have had more than a purely religious significance. They provided a venue in which marriage partners could publicly announce their procreative union in front of witnesses. The wedding served this function regardless of whether it was officiated by a priest or a judge, or whether state laws required a prior marriage license. Even if we believe that the rights and obligations of procreative partners philosophically precede the government, we still need to determine in what contexts procreative partners can seek recourse in a court of law. Defining marriage as being between a man and a woman isn't bringing the government into marriage, any more than determining the proper context in which government can defend and enforce property rights is bringing the government into property. So long as public policy reflects the natural law view of marriage and property, the government is grossly interfering with neither. It interferes only to the extent to which it gets either wrong. In conclusion, ending the practice of requiring government permission slips prior to marriage will not automatically end the debate about what marriage is and what it is for. And we can oppose marriage licensure without opposing civil marriage as a distinct legal concept.